Mr Chair.
I call David Clendon.
Yes, I thought so. So it's good to see this bill back before the House. The committee, from my recall, was hearing submissions on this about a year ago, and there was a sense of urgency about it because it was seen that that there is a gap in the legislation, and that we needed to remedy that. So as I say, it is good to have it back in the House. It's interesting, in the last few weeks, I believe, possibly more than a few weeks, there has been a series of programs on Prime television looking at the history of censorship in New Zealand. I think it's called Naughty Bits or some such. I've only caught a little bit of a few episodes, but it's actually been a really good reminder that when we're dealing with words like objectionable and indecent, or indecency in this instance, that we have to tread very carefully. These are incredibly subjective terms. One of the parts of the program I did see that gave me some amusement was back in the early 1970s. The film Ulysses came to New Zealand and was deemed to be of such an extraordinary nature that you couldn't possibly have men and women sitting in an audience together. So it was allowed for public showing to people over the age of 18, but men and women had to be segregated, which is extraordinary. I suspect today it could go on air with perhaps a PG or some such. The point being that our perceptions, our understandings, our social mores in terms of what constitutes objectionable or indecent changes dramatically over time, and we have seen remarkable shifts even in the last 30 or so years in New Zealand. So having said all that, I would say that the Greens are supporting this bill, primarily, and it's been touched on already, because it is seen that the legislation essentially has not caught up or has not kept up with available technologies. The internet, the availability of pornography, and particularly of child pornography, that it is now the problem, or part of the problem is, it's possible to observe such things which inevitably involve the abuse and harm to children without actually committing the offence of possession, because obviously to look at something online is not to possess it. This overcomes that gap in the legislation. I don't believe that people who accidentally click onto a website, and I guess we've all fallen into that trap at some point, you click on something that appears innocuous and suddenly you're looking at something that you'd rather not, particularly if you're using a parliamentary computer. So one quickly moves away from that site. But clearly that is not the intention, to catch people out. But where people are using this sort of material, it needs to be controlled, it needs to be managed, they need to be taken to task. The part of this law, this bill, that caused us difficulty and continues to, is the increase in the penalties. Because the evidence, I would argue, is overwhelming that increased penalties on their own are not actually an effective deterrent. We had not a lot of submissions actually on this bill, I think fewer than a dozen, and only a handful of people submitting orally, but they tended to be well-informed submissions, and that came through in a number of them, that simply increasing the penalty for a particular offence is in no way can give us any expectation of reducing offending rates. Where the investment needs to go is in treating people particularly who use child pornography. There's something wrong with those folk. They need attending to, and we need to understand what are the motives in that behaviour, and we need to deal with that to address those issues there. And I've argued before that we need specialist courts in the same way we have the drug and alcohol courts to deal with these cases, endeavour to actually heal them, to remove the temptation, or in some cases the need that these people seem to have to utilise this form of very objectionable material and damaging material. So we continue to have serious concerns about the additional penalties. But I guess we're still able to support the bill with the expectation that the judiciary will apply their judgment, obviously, not to, their common sense. They understand the social context, they understand the limited value of actually just simply putting somebody in jail for longer periods of time. So it's to be hoped that we'll get some positive outcomes around that the penalties will not, will actually involve treatment, dealing with the cause of the offending as well as the offending itself. Mr Chair.
David Clendon.
Thank you, Mr Chair. I've touched already on the issue of the definition of possession. This does, it's the points made in the committee's report back too, that the whole notion of sexual grooming offences, which are now, in many instances, it's much easier to commit those sorts of offences, to present to a young person, a naive young person, as a peer, as somebody you are not, in order to affect their behaviours and ultimately even to bring into a position where abuse can occur. So I think it's a very positive step that the recognition is there about those, just plugging the possibility or minimising the possibility or the opportunity for that sort of offending to occur online in particular. So the final, well, part of the report again does engage with these notions of indecency particularly, and the points made that there's actually not a definition of indecent in the Crimes Act and in this in other parts of the law where we do deal with issues around what's objectionable, what's indecent, what's outside of social, what's acceptable to people, to the so-called sort of responsible, normal person. Where we are, again, where we have some comfort is that there is quite a well-established set of case law, and I think that's the place to leave that with the courts to make those determinations, because I fear that if we endeavour to make a hard and fast definition in this place of what constitutes indecent, it's almost certain to fail, and probably fail in a relatively short period of time. Certainly within 5 or 10 years we'd be back here trying to unpick it. While initially it might look attractive to provide clear definitions, and often good law does that. It presents clear definitions, so there's less grey areas, if you like, less room for subjectivity in terms of interpretation. I think these sort of moral judgments that essentially are what these matters are best left to the judiciary, where the intention of Parliament is made very clear. We want and need to protect people, young people in particular in this instance. We want to remove this, the offences around child pornography and the like. We want to deal with people who feel the need to indulge in that sort of behaviour and deal with them humanely but forcefully at the same time. So I do think that, as I say, we're better not to endeavour to lock in definitions into legislation in these instances. So we'll have a bit more to say later, but for the moment I just reiterate our support for this bill. Thank you.